Awesome.
Good afternoon, everyone. I will just briefly say a few words. Well, first of all, thank you very much to our guest speakers today, Tiago, Bessa, who will be fully presented by Martim, but thank you very much. Tiago is a partner in a law firm that has a lot of projects with Nova, so he's a solid partner. And the other speaker, Marco, which I'm very happy to meet you today, Marco. Welcome to Nova. I think this is the first official event that you share with us, and I'm very happy to know that Francisco told me that Euroconsumers will start collaborating with Nova also. So I'm very happy to meet you and to greet you here, and thank you also for accepting our invitation to be speaking today about the Digital Services Act, in particular, the very important topic of moderation of illegal contact and data protection. So thank you both. I don't know if Francisco wants to say something before moving to Martin.
Yeah, very brief words, just to thank both Tiago and Marco. It's really a pleasure to have you both in our last webinar of the year. We'll be presenting the webinars for 2023 in the coming weeks. And next week, we have a special webinar of presentation of the Yearbook of Data Protection for 2022. So we are able to finish the book before the year ends. We are very happy with that. We hope to do it much shorter next year. And we are going to open a call for articles, and we see that today we have lots of people attending. Thank you very much for being here with us, and please send us articles for us to publish in the yearbook. So we'll give the floor without much further ado to Martim, so we can start this wonderful session. Thank you.
Thank you, Professor. So thank you for coming, especially for our speakers. Marco Scialdone and Tiago Bessa. So the topic is very clear: the Digital Service Act and data protection, in specific the problem of monitoring illegal content, but not only, because the DSA is a very broad regulation that has a lot of things coupled with it. As the first speaker, we'll begin with Tiago Bessa. Tiago Bessa, as already referred, is a partner at VDA in the areas of information communication technology and IP transactions. He has worked in numerous matters and transactions in different industries, such as electronic communications, postal communications, media, entertainment, and gaming, and technologies. He's very active following cross-cutting areas, namely copyright, internet law, and consumer law. It's a pleasure to have you with us to talk about this topic. The floor is yours. Thank you.
Thank you very much. Let me start by appreciate the invitation by the Observatório of Data Protection, Personal Data Protection, and especially to Graça and Francisco for the invitation. Also, thank you, Martin, for moderating the debate, and a special compliment to Marco for being the guest speaker as I am. So it's a pleasure for me to be here today with you. As Graça mentioned, at VDA, we have a strong relationship with Nova that has led to a very different projects, but one of the most emblematic is the research center What Next Law, which is focused on researching the future of law and trying to also present some proposals to topics that we are facing as a society, as consumers, as citizens right now in the world. So for me, it's a pleasure to be here with you, and especially to be able to talk on a topic that is very interesting and personally that I'm very keen of, which is the DSA, the Digital Services Act. It is in fact a very important regulation. Let me say that I'm a little bit proud of what Europe is doing on this matter, because in fact we are as Europeans trying to tackle some of the most pressing issues that we have today in a digital society, in a digital economy. And so Europe is somehow paving the way tackle the most pressing issues. And of course, we have the DSA, we have the DMA, we have the draft Artificial Intelligence Act. We are acting, and Graça knows this very well, on data sharing, data economy, data protection. We also, as Europe is very observative and keen in also addressing the topics regarding crypto assets and the cryptocurrencies, NFTs. So I think it's a very good timing, not only for lawyers to be working, especially in tech areas, but also as Europeans, we are seeing that we are somehow paving the way to the future of regulation in these matters. And regulation is not bad. Regulation sometimes is needed. And if we see most of the, let's say, opinions by entities that are investing in these new markets, most of them say that they need regulation. They need transparency, they need clarity, they need stable rules in order to decide in what to invest. So regulation is not bad. Of course, we know that sometimes regulation can be premature, and sometimes when it is premature, it may detract or impede the development of technologies. But on the topic of DSA, I think it is needed right now. It is needed. And as you mentioned, Martim, the DSA is a very broad regulation. I'm sure we'll try to tackle some of the most important topics, so I don't want to take the floor for long. But it has very, very important rules for the development of internet. And of course, it builds on what was decided 20 years ago. And it's important to say that the e-commerce directive has 20 years. So it was one of the most important acts in order to develop internet, as we know, this amazing innovation right now. And so it does not revise, it does not revoke the e-commerce directive. So this landmark directive, or this landmark case in European Union law, still continues, and the DSA builds on that. And it also interacts with many different acts. And so maybe one of the first ideas that I would like to share with you is that do not consider that the DSA, including the DMA, is the only act that you need to know in order to be able to move in troubled waters that are now the digital landscape, because the DSA is just a puzzle, just a piece, sorry, in a very complex puzzle, because you have, as I mentioned, the e-commerce directive, you have specific acts from the European Union tackling illegal content. So the DSA is not only one of them. So you have, for instance, directives on sexual abuses, regulations on the transmission of terrorist content. You have copyright, also rules, audiovisual rules. So we have a broad landscape or different rules that may have also a place in the content moderation and in tackling illegal contents. So please bear in mind this. Is not the only act that you need to consider. And on top of that, and this is an additional layer of complexity, we also have national law, at least in Portugal, that we need to consider. Maybe it is different in other countries, and maybe Marco can also explain to us what is seeing in terms of benchmark. But at least in Portugal, we have what I could point out as two very important laws also in the topic of regulating the internet and regulating the illegal contents, which is the Charter of Fundamental Rights in the Digital Era, which is a law from 2021, so very recently. It has important rules on this matter, very important rules on this matter. It defines the principles and the objectives that the legislator should attend when tackling these issues. So this is an additional layer of complexity in this very big puzzle that we have. and also ensuing the Fundamental Rights Charter, we have this law 82 to 2021, which specifically tackles the removal of illegal content. So intermediary service providers, namely hosting and internet service providers, if we could forget about the e-commerce directive and the DSA, if they do not exist, they should consider the national laws that also tackle illegal content. And so this is a web of rules and principles that are very difficult to interpret, very difficult to intertwine, and to provide, at least from a lawyer's perspective, clear rules and clear advice for our clients. So despite regulation being needed, and I will end with this comment, what I see today is in fact a web of different regulations that turns very difficult for investors to know what they can and what they can't do. So perhaps this is something that we could better in the future.
So you consider that by using a very broad concept of illegal content in the DSA, it was well, it was a very hopeful idea, but there's these drawbacks that need to be considered. Like you mentioned the puzzle of different acts and regulations and legislation that also applies. The entire European Consumer Law Acquis is applicable, and it has different any violation of those rules and the way those rules are transposed in each member state, which can happen in very different ways, can correspond to an illegal content, to a violation, and this is probably going to be a very problematic aspect of the DSA, because due to all the differences across each member state.
Yes. So I don't want to monopolize the event, but let me just say that, yes, I agree. So the concept of illegal content is very, very broad. So it is, and maybe we can tackle this in a few minutes. But I mean, the motto was, as you know, from the European Commission, the motto underlying the DSA was, what is illegal offline should be illegal online. And so this leads to everything can be illegal. And for sure that we have a lot of academics talking about that illegal content has a specific connection with copyright. For sure, it is. If you violate copyright, your content can be illegal. But just for you to be aware, illegal content, it goes well beyond copyright. So it's any kind of information that is not in compliance with union law or the laws of any member state. So it's not only union law. We should also consider the specific national laws. And as I explained to you, in Portugal, we have specific laws that are not just the transposition of directives, that we also need to consider. So it is very broad, in fact, and again, this leads to some uncertainty on what intermediary service providers can and can't do. But now I believe that we should give the floor to Marco. Sorry for taking so long.
I was thinking about, for example, defamation laws. That's probably going to be another wrench in the system due to different standards for free speech across each member states. But let's jump on to Marco, because we are very waiting his participation here. So Marco Scialdone is, sorry, scrolling up. He's a lawyer and an adjunct professor of law and management of digital content and service at the European University of Rome, where he's the deputy coordinator of the LLM in artificial intelligence, law and ethics of emerging technologies. PhD in legal categories and categories and technologies. In 2018, he was also appointed by the Italian government in an high-level expert group on AI, and in 2019, appointed member of the Italian Permanent Advisory Committee for Copyright. He is currently head of litigation and academic outreach at Euroconsumers, the main international group of consumer organizations uniting Tests ANACOP, Tests Achats from Belgium, the Euroconsum from Italy, Protest here in Portugal, OCU in Spain, and Protests in Brazil. So very important and organization in the defense of consumer interests offline and online too. Marco, the floor is yours. It's a pleasure to have you amongst us.
Thanks for having me. It's an honor to be here with you, and also a pleasure because we signed as Euroconsumers with Novalo School a memorandum of understanding just a couple of months ago, and we will have the pleasure to bring our Consumer Leadership Academy at Novalo School at the end of 2023. And also we already had the chance to collaborate with Francisco, for example, for our annual call for paper that is called My Data is Mine, that we present every year at Web Summit in Lisbon. So the new call for paper will be out, I think, on March or April next year. So it's also an invitation for you all to join, to participate, to submit your papers and have the chance also to present it at Web Summit next year. Coming to the topic of our discussion, let me share this presentation that, okay, so you should see it now. And yeah, because it was really really interesting, the last point that we mentioned about illegal content, because there is as we can see, there is also a kind of moral approach in the DSA when we switch from the illegal services or illegal content to the harmful content, which is something a little bit different, because of course we can frame the illegal one more easily because it's something basically against the law of the union or member states. But when it comes to harmful content, it's a slightly different concept, and talking about freedom of speech can be something interesting to tackle and also very dangerous if we tackle this in a way that is too broad. The Digital Services Act also, it was mentioned before, the Digital Markets Act, just to frame these two important heavyweights of the European legislation. They began basically together in 2020, so a couple of years ago. And the strange thing is that initially they were conceived as a unique test. So in the origin, this should have been a unique regulation, both for the services and the market. Then along the way, they were split in two different texts. So they were presented as two different texts in 2020. And it took 2 years to arrive to the final text that is one that is entered into force in November 16, as you can see in this timeline. But quoting the song of the AC/DC song, it's a long way to the top if you want to rock and roll. So as you can see, it's a long way to the top if you want to have the DSA applicable for all the digital services, because we have just started. So in November, the DSA enters into force, but this doesn't mean that the disposition of the DSA are already applicable for digital services. As you can see, there is a long timeline, because first you have to identify new specific subjects that are the DSA has introduced for the first time. These very large online platforms and very large online search engines. And then you have the first moment when the DSA will become applicable for those subjects, so in July 2023. And we have to wait more or less 1.5 years to reach the final applicability of the DSA for all the digital services, because it's a very complex regulation. where sites matter. As intentionally, I didn't use any kind of image that can have a double meaning, but sites matters in the DSA. Why sites matter? Because on one side, DSA applies to all the online intermediaries providing services in the European Union. So this is exactly like the GDPR, but unlike the GDPR, the obligations are introduced in a proportionate way to the number of users, to the dimensions of the providers. So we switch from a kind of one-size-fits-all regulation that was one of the e-commerce directive that was mentioned before, to a kind of regulatory ladder in the regulation of the internet services provider. This is because basically what the experience of the last 20 years has taught to us is the fact that that kind of approach where basically there were three categories of intermediaries and they were treated exactly in the same way. The small, medium enterprise and the big tech, they were treated exactly equally. This is not in line with the experience of the market anymore. The other point, which is pretty interesting, is that the Commission will have this exclusive power to supervise the very large online platforms and the very large online search engine for the specific obligation of this type of actors. So if you can see the difference between the GDPR and the DSA, one of the points that the experts, the company have complained about the GDPR was that was not able to foresee a kind of scalability in the terms of the commitment required of this SME compared to the big tech. Instead, the choice in the DSA is to identify a new category and based on the dimension of the provider of a single category to introduce either obligation for the provider whose dimensions are either. So this is the first point that I want to tackle. The second point that I want to tackle is the fact is what in the DSA is called systemic risks. Because one point of the regulation that I think it's pretty interesting, that if you compare this to the e-commerce directive, which was pretty focused to the market. So it was a regulation focused on the effects on what at the time was called the new economy. Now this regulation is more focused on the society as a whole. So what is the effect of these subjects on the society as a whole? And you can see this especially in the provision about the systemic risks of the DSA, because as you can see here, the analysis that this kind of subject has to carry out annually to monitor the kind of risk associated with their activities, and in particular with the dissemination of legal content, is not related exactly to the effects on the market. So the fact that there is an illegal content on market is a problem because, of course, the people can switch from the legal content, which usually has an higher price, to an illegal content which has lower prices. It's not like that. It's not for that reason. It's because of the negative effects on fundamental rights. Is because of the manipulation of services affecting democratic processes and public safety. Is because of the negative effects on gender-based violence, minors, serious consequence for the physical or mental health of users. As you can see, this is an impact not on the economy, but on the society. So there is a kind of moral approach, ethic approach in the DSA that was something that was absolutely not present in the e-commerce directive, because at that time, the approach of the regulation was, I want to regulate the market. I don't have a clue what this kind of platforms at that time. There was indeed no platform at all, no platform economy at all. I don't have any clue at that moment of the systemic risk that this platform can generate. The third point is about the safe digital market. And again, you can see that there is also in this a different kind of approach than in the past. I just take two examples in the DSA. One is the provision about dark partners, the Article 25. The other one is on the recommendation systems, because the provision on the dark partners and the obligations to not use interfaces that are deceptive for the consumers. This can be seen on in a kind of way as the continuation of the traditional approach of the rationality of the consumer and the information asymmetry, meaning that of course the traditional theory is that the consumers tend to act rationally, and the problem is that there is an information asymmetry in the market. So if with more information we can fill the gap, the consumers will do the best for his own. In the case of the dark partner, the dark pattern, the result seems to be that the regulations tend to agree with the fact that it's not possible to fill this gap, because when the interfaces of a specific service is built in a certain way, it's not possible for the consumers to reach that kind of information, because to reach that kind of information is basically prohibited by the interface that the service is using that moment. So that's why this kind of regulations tend to set up specific rules on this matter. On the other side, we could also say that these were practiced already forbidden by the unfair commercial practice directive. Yeah, it's exactly also in this, is covered by that piece of regulation for sure. Coming to the recommendation systems, also in this, it's interesting because on one side, there is the recognition of the fact that this recommendation system allow the user to quickly access to relevant content. But once again, we have problems with the transparency of this kind of recommendation system. So once again, we want to introduce again informations to the consumers to know the parameters of the recommendation systems in order to improve the information for the user and the choices that they make. So I provide the consumers with information. The consumers is more aware of how the recommendation system works, and the impact on the online behavior of the consumers is mitigated. But once again, in the regulatory ladder that I mentioned before, when it comes to the very large online platforms and very large online search engine platforms, in this case, the option in the regulation is that this kind of internet provider must offer the user a content recommendation system that is not based on profiling. So when this scale up at a level that information cannot fill the gap anymore because the power of this kind of platform is too much for the single user, in this case, the regulation intervenes, say, okay, this is forbidden, or at least you have to offer a different kind of option. And just to close the loop, with the moral approach that there is behind this kind of regulation and how the moral approach can influence the regulation based on the system, it's pretty interesting the fact that on March of this year, a regulation on algorithmic recommendation services enter into force in China. And so it's pretty strange that this was regulated before in China than in Europe. But you can see in China how the moral approach is more and more evident. So this regulation has the goal to promote the core of the socialist values. And what are the obligation for the algorithmic recommendation services provider? They are to actively disseminate positive energy and promote the application of algorithms to be good, not set up algorithmic models that induce users to indulge in addiction, excessive consumption, etc., not generate synthetic false news or disseminate it, not use the algorithm to falsely register accounts, illegal transaction accounts, manipulate user accounts, or falsely like, comment, or forward, etc. So as you can see, there is a moralistic approach in each and every of these regulation. This piece of regulation is obligation on the provider. And another point that it's interesting is the difference between, as you can see from the algorithm recommendation on minors, when they are used to provide services to minors, the provider shall facilitate the usage by developing models suitable for the characteristic of minors. So minors obtain information that is beneficial to their physical and mental health. So it's not forbidden at all. Instead, they are used to promote certain kind of value. And when it comes to the elderly people, in this case, they have to consider the needs of the elderly for travel, medical treatment, consumption. So as you can see, is that just a regulation to push the people in a certain direction, for the minors in a certain way, for the elderly in another way. And also there is a specific obligation for the consumers, an article for the consumers. So the Article 21 of this recommendation is to protect consumers' right to fair transaction, is not to use algorithm to determine transaction prices or other transaction conditions based on the characteristics such as consumers' preferences and transaction habits, and not implement a reasonable different treatment. So, and this comes to the end of my presentation. One point that maybe it's interesting to tackle in the discussion is the fact that all the narrative about both the DSA and the DMA at a certain moment was not more a debate about how the regulation should intervene in this kind of markets. It was more and more a kind of moral approach to the regulation. And this reminds me a book that I read many years ago about copyright in 2009 by William Patrick, this moral panics and the copyrights war. That was pretty interesting because especially in copyright, this technique was used to introduce the regulation that was more and more restrictive in the copyright field. Because the metaphor, as William Patrick wrote in the book, are powerful weapons and are employed in the copyright wars as weapons, not as figures of speech. And if you read a lot of the disposition of the DSA and the DMA, and you also see the debate about DSA and DMA, you will find that there are a lot of powerful weapons that have been used to reach this kind of results. So I stop here and let's debate.
Thank you, Marco. It was a very good presentation. You raised a lot of important topics and places where we can start tackling and picking away the DSA itself. So going back to the policy approach of informing the consumers, you raised the point that in a lot of the way that the European law has approached a lot of these problems is by trying to solve one of the main problems in consumer relationships and user relationships in the internet, which is information asymmetry. Do you find that this approach is as useful and as meaningful, as efficient as it's normally promoted in these types of legislations? Because what we see in practice is the number of transparency requirements, they evolve in terms of size. No one reads them, and the environment stays the same. And this question is for both of you, Marco and Tiago. Feel free to talk about this problem.
If I may jump in, I totally agree that we have an overload of information. So basically in the last 50 years, the response to all these kind of problems, okay, provide more information to consumers. At the end of the day, you have this long text with general conditions, the privacy policy, the cookie policy, nobody reads it. So maybe it's time to change the approach and to to stress the importance of the legal design of this kind of text. So I don't need more information, I need clear information. So if you consider, for example, what has been done many years ago in the copyright regime, in the copyright field by the Creative Commons project, this is exactly what we should replicate in other domains. So you have a long license, which is complicated to read for non-lawyers, but you also have the Commons deed, just one page, very short, and you know exactly what are your rights, what can you do with the content, what you cannot do with the content. We should push the same in the other fields. Privacy law, for example, it's a field that would perfectly benefit from that kind of approach. What is the need of having 2-3 pages of a privacy policy that nobody reads, when you can have something which is just 1 page long with figure, with pictures, and you understand what are your rights, how you can exercise them, and then proceed.
Thank you. Tiago?
I mean, I agree with what Marco said. So in fact, it seems to me that the DSA will require change in the terms and conditions. So I'm recalling Article 14 of the DSA that in fact determines that all intermediary service providers, irrespective of being small, large, very large, must change the terms and conditions. And for sure that most companies subject to the DSA will in fact include more information in the terms and conditions. So we can have a load of information that consumers usually don't read, usually don't understand. So this is in fact a problem. I notice nonetheless that there is some concern from the European legislator when specifying, let's say, some rules on the way the terms and conditions must be presented to consumers. And so if I recall correctly, I think that even in Article 14, it is determined that terms and conditions must be in clear, plain, intelligible, user-friendly, and unambiguous language. So, and they shall be available in easily accessible and machine-readable formats. So there is, in fact, this concern of the legislator that information should be user-friendly. Information should appear in a way that consumers can read it. But having said that, for sure there is a major concern for very large platforms, because in that case, even the Article 14 determines more additional requirements. So it is a ladder, as Marco explained, of regulatory obligations that will impose more rules, more requirements in very large platforms or search engines, and not just in all intermediary service providers, which makes sense because, of course, very large platforms is the services that most of us throughout the world use. But having said this, I'm recalling, in addition to the example that Marco mentioned about the Creative Commons, that the European legislator is trying to tackle this. So, for instance, if we consider another sector where we have a bunch of information that most people do not read, which is the electronic communication sector, right now, the legislation determines that in addition to the terms and conditions that must contain all information and that sometimes can be 20 pages long, we must have, let's say, a resume. We must have a summary of the terms and conditions, which is just 1-2 pages. And this is mandatory. So operators, they need to provide the terms and conditions, but they also need to provide the summary. If they don't do that, they will be in breach of law. And so maybe we could use this example to determine not just the way the information is designed to appear to consumers, but also to oblige undertakings, companies, to have this summary. So what is in fact the most important information that somebody needs to see and to agree in order to subscribe a service, in order to buy a product. So I think the legislator has already perceived that there is a problem, that it's not tackled by more information in terms and conditions, that needs to be tackled in a different way. So I think we are paving the way to more creative and innovative solutions in terms of presenting the information to consumers.
Thank you, Tiago. In your first, when you first spoke, you mentioned a lot, and we started a convoy on the problem of defining illegal content. I'm going to the next neighbor topic, which is how to deal with that neighbor illegal content, namely the systems with notice and takedowns, which over these last 20 years, there's certain commercial practices arose trying to comply with both sides of Atlantic, the MCA on the United States for copyright, in the European Union, the different transpositions of the e-commerce directive, and then later on, the copyright in the Digital Single Market Directive, namely the Article 17. And now the DSA kind of decides to codify a lot of these practices, which were supposedly followed, even if not usually very strictly obeyed on, or they were presented in a certain manner, but not followed as such in practice. This question also for both of you. Do you believe that this new framework will tackle is good? First question is it a good improvement? And the second one, and does this tackle the problem of the chilling effect? So normal people post a photo with their son or daughter, and the algorithm flags it because it might be child pornography and it's illegal content, and decides to lock a person's entire account, which for example, there was a very real case of a father that sent a photo of his healed child to the doctor, and it ended up with losing entirely its access to all the Google accounts. But also for copyright, where a person tries to post a video of her strolling down the street and there's someone playing famous music, the copyright system flags it as a violation of a copyright infringement, and the person's content is blocked. Normal people don't know how to deal with this. So there's this problem with the chilling effects. Another question for you. I'm sorry, I was starting to ramble a lot.
Maybe.
Is Marco?
Yeah, I go ahead. Yeah, it's a broad topic. Different point. One point that I would like to say to tackle is the fact that, at least in my opinion, that the DSA doesn't innovate a lot in the topic of removing illegal content. Of course, is introduced this kind of ladder in the regulation based on the dimension of the provider. But there is a lot in the DSA that comes directly from the experience of the European Court of Justice. So it's a kind of the lesson that we have learned in the last 20 years with the jurisprudence of the European Court of Justice, especially in the different kind of role of the active or passive hosting provider. So there is a kind of introduction in the law of principle that were already raised by the European Court of Justice. The second point is that the problem that we face now is that the removal of content are more and more in the hands of systems which are not human. So the revision is not a human revision, but is made by artificial intelligence systems. So this can lead sometimes to consequences which are unintended. So the problem is now is how the platforms are implementing systems that let the human to be in the loop in a certain moment, because sometimes the problem is not that the content is removed, but the fact that content cannot be restored because there is no human behind that can restore the content. And usually the consumer has no interest in going to court to have a certain kind of content restored because there is no economic interest in doing that. Or if the procedure, even the internal procedure of the platform is too long, at the end of the day, you give up and so the content is definitely removed. In a certain way, the Article 17 of talking about the copyright, in the Article 17 of the Copyright Directive could also be an improvement of this, because you know, the license that the platform has to get to host this kind of content covers also the user-generated content. So at the end of the day, you will benefit from a license which is paid by the provider, and you can upload content with copyright material on the platform. So this could lead to an improvement. Could lead to an improvement of the in the unintended removal for copyright reason. But of course, what we have experienced in the last 20 years, both in the United States with the Digital Millennium Copyright Act and in Europe with the e-commerce directive, is the fact that sometimes copyright is used as a tool to remove content which have nothing to do with copyright violation. Basically, it's just a way to censor this a certain kind of content. So you use the copyright as a kind of censorship tool to remove some kind of political speech. It's sufficient to have a kind of music in the background, as you were mentioning, or the fact that it's a piece taken from a TV show. And this can use also in the side, not because this is exactly in line with the copyright regulation, but because the person that should be in charge to activate a kind of exception to the regulation has not any interest in doing that, because the content is removed and you are not any interested in restoring the content, basically.
Just before passing to Tiago, I just like to raise a problem that sometimes putting a human on the loop does not itself solve this problem, due to the massive amount of information, which is not humanly possible to review all appeals, and the fact the human element itself, the people that are a lot of times hired for those positions in the very large online providers right now are not, they don't have the proper education formation for the task that they're handling, or they have inherent bias, because a lot of times they're also hired in countries with a lot of different social values.
Yeah, and you are totally right. And I think on this, the provision of the DSA on trusted flaggers can help. So the fact that you can appoint specific subjects which can be considered trusted by the platforms can help in avoiding the problems of the overloading of the human in the loop that has to take care of this revision. So the fact that this revision comes from a trusted flagger can also facilitate the restoring of content which are perfectly legal.
Tiago, sorry for this add-on question. Now your statement, please, your opinion.
No. I mean, very, very interesting. Let me just try to supplement with a couple of points. So the first point that I would like to say, and I mean to the benefit of the audience, is that the DSA does not change the, let's say, the liability framework of intermediary service providers. So from the e-commerce directive, and this has not changed in the DSA, intermediary service providers continue not to be liable for the information that they convey, or that they host, or that they cache momentarily. So the principle, which is in fact a very important principle for the development of the internet as we know it today, does not change within the DSA. And this is completely in line with the jurisprudence of the European Court of Justice that has addressed several cases where, of course, companies more connected with copyright infringements for sure were trying to pose some burdens on the intermediary service providers to have a more active a more active, let's say, role in policing or monitoring the internet. So this has not changed. Of course, there are some exceptions to this, as Marco mentioned in Article 17 of the copyright in the digital single market, that may be a little bit beyond this principle, but this has not changed. But the fact that intermediary service providers may not be liable for the information that they carry or that they host does not mean that they are not accountable for. And this is a very, very important difference, because intermediary service providers play an essential role in the internet ecosystem. So we need them in order to tackle illegal content. We cannot survive or we cannot fully address this topic, which is of public interest for sure, as we were talking about, without the intervention of the intermediate service providers. And so they may be accountable, and they are needed in order to attain this objective. And that's where I place the notice and takedown procedures, because I believe that the DSA went a little bit further on the notice and takedown. And let me give you some examples. So the first example, at least to my knowledge as a lawyer, is the possibility that, for instance, in Portugal, I've never saw it, for internet service providers in Portugal to receive orders to block content from authorities located in different jurisdictions. So this has never happened, at least to my knowledge, in Portugal. So traditionally, internet service providers would have an order for a court or from an administrative authority in Portugal in order to block content. With the DSA, this may change. And of course, this raises problems. This raises jurisdictional problems in order to see if entities, authorities located in other countries may send an order for instance, internet service providers located in Portugal to block some illegal content. So this is a first topic that I would like to raise, and that in my view, the DSA is trying to better tackle illegal content, which is not new, because at least since 2017, the European Commission started to issue first a communication, then a recommendation on how to better tackle illegal content. So it was expected that somehow this matter would be reinforced with the DSA. So in order for them to be accountable, we have this first line, which is some court administrative authorities that may, of course, request intermediary service providers to block content or to remove content. And then we have the other perspective, which is notices from users. So anyone can send a notice to an internet service provider, a hosting provider, saying that they are hosting an illegal content. And after this notification, they have a special duty of inquiry, let's say so. So they have a special duty to analyze if in fact the content is illegal or not. And as we explained before, the concept of illegal is very broad and may encompass harmful content, just harmful.
And the notice itself can be placed by different kinds of entities. It can be a court order, an administrative order, or a private order from a company or an individual citizen. Exactly.
So if they receive this notice, they have a duty to inquire. And if it is a notice, as Marco explained, from a trusted flagger, I would say they have a reinforced duty of inquiry, because what the DSA mentions is if the notice is sent by a trusted flagger, they must act swiftly in order to see if the content is illegal or not. And why this is important? This is important because after the notification, they became knowledgeable of an illegal content. And if they do not act swiftly, they can become liable. So we start by accountability, and then we can have liability for intermediate service providers. So that is something that I believe that is also a change within the DSA. And the last point is what they can do, what these providers do within the content moderation. And so it's very interesting, because if we read Article 17 of the DSA, when they are aware, these providers are aware of illegal content, they can do several things. And this is options that for sure were already in place, but somehow the DSA codified. So they can implement restrictions on the visibility of specific items, of course, removing, disabling, or demoting content from the search engines, for example. They can suspend monetary payments, which is very important in order to better tackle illegal content. They can suspend the service in all or in part, or I would say at the measure of last resort, they can suspend the services accounts for the specific user. So this is, of course, is proportional. So we should start by the least intrusive measure to the more intrusive measure. And just a last notice, which for me is striking, because it's very relevant also in the regime of the DSA, is that illegal content, or in this fact, content moderation, is not only for matters that can be illegal due to non-compliance with union law or national law. Okay, we can also have content moderation if the content itself is not in line with the terms and conditions of the service provider. So I can place within the terms and conditions more stringent measures than the ones that were approved by the legislator, and then I can moderate content based not on a potentially illegal content because, for instance, it violates copyright, but just because it violates my terms and conditions. And this is something that, in my opinion, perhaps the European legislator went a little bit further, because it implies that somehow the service providers may create law, and they may decide to act based within the law that they specifically approve, which is something that, considering all the concerns that the DSA has, as Marco explained, the moral perspective, the equilibrium that they want to attain between attacking illegal content and reaching a very level playing field, let's say, in terms of protection of fundamental rights, is something that I believe it's outside this equation, because it means, as I mentioned, in something that for me it's a little bit concerning, is the possibility of providers having their specific laws and acting within their specific laws.
Because this can be anything. It could be a forum for posting and discussing a very specific subject, for example, faxiology, the designs of flags. And they say that when someone posts a video essay commenting on a recent political situation, it's not according to the terms and conditions, and it's not the subject of the forum, so they delete it. But it could also be very moral questions. This could be the terms and conditions themselves could be a Trojan horse to impose impose restrictions based on the morality of the provider. And here it's the constant problem of content moderation, and which occurs a lot in discourse about copyright, which is this kind of a Trojan horse that can be used for very nefarious reasons. Okay.
And also, if I may add, also on this, it's interesting the new provision on Article 7 on the voluntary investigations, because this is something that this also comes from the jurisprudence of the European Court of Justice, because basically this disposition allows the internet provider to run voluntary investigation on the presence of illegal content on the platforms without losing the privilege of the safe harbors. Because before of that, of course, there was a debate that also was at the level of the European Court of Justice. If I proactively start searching for illegal content on the platform, am I still able to use the safe harbors, or I'm becoming a traditional publisher, so I lose this privilege on the e-commerce directive? And now it's crystal clear that you can do this voluntary investigation without losing the safe harbors. So maybe we can expect more and more intrusive approach from the platforms to start investigating the content in the platforms, maybe using the terms of condition, maybe using artificial intelligence system to detect content that are against the specific terms and conditions of the platforms, and removing the content. Officer with an independent position.
Yeah, I mean, it's just to add, Marco, it's the Good Samaritan provision. So
yeah, exactly.
Exactly, which originally, if I believe, it came from in the United States in the Content Decency Act, which itself is a regulation marked with a lot of moral and moral provisions. So we could see that sliding stair of problems. Here, Tiago posted a question: is there some kind of content moderation officer with an independent position? So sort of a data protection officer inserted in the corporate structure of a company. I don't believe so. If you want to add anything,
but I think it's important that for the first time there is a clear right for the users in get an explanation when they receive, for example, a suspension of their account or a deletion of their account, because in this moment most of the platform, basically what they say is okay, this post violated the terms of conditional platforms, but you don't know exactly what you did.
They don't identify the violation.
Sometimes your account is suspended that you don't have any clear indication on what happened on the platform. Now at least there is a clear provision on this. Hopefully the platforms will start giving a clear explanation. And I think this is really important, because sometimes people use this kind of platforms not only as a service, but also as a real part of the social life. So you are,
it's an extension.
It's an extension of your private life. So sometimes you lose months or years of your life and you don't know exactly what happened.
There's the DSA. Oh, sorry, Tiago, you first.
No, I mean, just to answer to the question. In fact, we don't have a DPO similar provision within the DSA, except for the very large online platforms and search engines. So if you go to Article 41 of the DSA, at least these entities have the obligation to nominate a compliance function with independence from the boards, and so that will more or less be a DPO in order to ensure compliance with the DSA. And this is in fact something that the European Commission is very keen to oblige companies, and then Twitter, perhaps you are following the news, they had some important problems because the people that were supposed to have these compliance functions left after the Elon Musk takeover, and so the European Commission was very concerned on who should have this compliance function for Twitter at least in the European Union. So this is in fact relevant, and to agree on the point that an additional topic and novelty of the DSA is in fact the need to present explanations. So this is really important. This is throughout the document where this concern is spelled out, and I think that a very important rule here is that even if we can expect that content moderation will be made by automated machines, by algorithms, and so this is something that the DSA does not forbidden. In fact, it is well aware, the legislator, that this will need to be implemented. There's no other way around, and so that's why in the transparency reports that the intermediary service providers need to publish each year, they need to explain how they are doing content moderation. If they are handling consumer complaints by natural people or just by automated means, they need to explain it. So this is something that the legislator accepted. I would say in the wave of Article 17 of the copyright, which is well debated, if the filters mechanism would be possible to implement such a filtering mechanism without resorting to automated machines. And I believe the answer is no, it's not possible to do that. So this is something that the legislator accepted, but it has put a burden on providers to explain why they are doing this, if the measures are proportional. And in fact, a very important topic is that if there is a complaint after, let's say, a content moderation action by service providers, the decision on the complaint cannot be taken just by automated means. If you see, I think it is in Article 25, it is clear that in this case, if there is a complaint after, for instance, a suspension of the accounts, the complaint must be addressed by appropriately qualified staff and not solely on the basis of automated means. So I think it is good because, of course, they consider that it's not possible to tackle illegal content without the help of machines. But in some cases, there are some objectives that require the intervention of human and require, in fact, the analysis of human people that should be, of course, appropriately qualified and trained. So I think this is interesting.
Okay, Marco, do you want to add anything?
Just that this sounds pretty in line with the provision of the GDPR on the right to human revision in the automatic decision. So I think it's a trend also in the regulation, pretty clear, and it's a standard that the GDPR set. So it's, I mean, all the pieces of regulation where the automatic system is involved, they provide a kind of human revision. Also in the AI Act, it's like that. And it's good to at least to know that there will be a human behind any machine decision also in the future.
I think the matter and the problems of compliance were already raised. I think we can follow a segue into that topic. So it was raised here an idea or a format for a position for a content moderation officer, which I was not very familiar with this provision. I thought about only the contact points, but within the role of this kind of functions within the corporations, there's going to be a lot of audits, either made by the companies themselves or third parties, or due to the investigations. Do you believe that all of these new provisions regarding the assessing of risks and systemic risks, are they going to actually translate themselves into meaningful actions and meaningful effects for the average users? Are these provisions that force the popping of the hood of the car to see the engine going to actually be meaningful and useful?
I think
Which one wants to?
I think it's really difficult to answer. Basically, we are creating the framework for this to happen. So having the big platforms more responsible for their activities online, both on the side of the users, consumers, both on the responsibility for the society as a whole, I think it's a good step ahead. Of course, it's a long way because there is this regulation needs a lot of implementation activities. Some of these will pass through a dialogue with the Commission. I think it will take time, but this will change not only the market, but also the role of these platforms. Sometimes I think that the the regulation start considering this platform of a kind of essential facilities. So maybe their role could change also in this way. So the obligations that are put on these platforms are not the regular private ones, but also in light as they can be a kind of public role in the society.
Well, I tend to agree. In fact, I believe it's very difficult to answer right now. As Marco explained, the timeline for the implementation of the DSA has just started. So we know that the Commission within the DMA and the DSA have a very important role in terms not only of supervising the execution of these two acts, but also to approve some guidelines in order for better enforceability and for better analysis for all the parties involved. So it's very difficult to ascertain right now what will be the impact of the DSA. But for sure that considering the level of obligations that we have, particularly to these kind of big platforms that are not exactly the same as gatekeepers arising from the DMA, but more or less the same very large online platforms and search engines will be gatekeepers within the DMA. So that they have a set of very stringent, complex, and comprehensive rules. So of course we should expect some changes, and we should expect more monitoring and more supervision, not only by the European Commission, especially within the DMA, for the gatekeepers and for the very large online platforms and search engines, but also from national authorities. And we have this role of the coordinator of this digital services that, in my opinion, is not an independent or regulator as we are seeing in other sectors, but for sure we are moving in that direction, my opinion. So it is expected that all European countries will appoint a coordinator. This coordinator should have sufficient staff, money, and authority to implement the DSA, and it will have very important powers in order to tackle illegal content, in order to supervise the activities of the intermediary service providers. So I believe, although it is premature to say what will be the outcome, I would say that right now we have more tools in order at least to tackle some of the pressing issues that have been appearing in the news quite recently on the bad use of this kind of platforms and let's say the conveyance of illegal content and the harm that specific fact can cause to the society and to specific people.
Okay, thank you, Tiago. You already raised my second question, which also aligns with the question placed by Diogo here in the chat. Thank you for your opinion regarding the problems regarding the audits. Right now, I think there isn't anyone that's which isn't part of the platform themselves, which could provide these functions for auditing. There's even in the private sector and the European Commission itself, there's not people that are ready for pursuing those kind of activities. You raised the points of the coordinators. There are a lot of people that have made the comparison with the figure of the coordinators and the board of the digital coordinators with the same structure that exists in the GDPR, which came from the directive. So each individual member state as an independent regulator for the matters of data protection and for within very specific enforcing powers in several acts, namely the GDPR right now, to supervise and investigate and apply fines to the companies situated within their member states, and then there's the board and the supervisor with specific roles for European-wide problems and activities. And right now here in the DSA, we find a similar mirror structure with the coordinators in the member states, the boards, and the functions of supervision of the entire European Union digital markets is in the Commission, which probably came, I think, from an inspiration from how competition law is applied. So in competition authorities in the member states, competition authority, and then the Commission itself has its own role across the single markets. I want to ask your opinion about these new figures, the coordinators, whether it is expected that there's going to be very different kinds of coordinators across the European Union, namely in their funding, in their independent or not independent character, or basically non-existent character, being completely under the wing of a political function, for example, the government, and a specific minister, a member of the government, and whether or not the creation of this new figure could cause, and this is raised by Diogo, problems of entropy I'm just going to read. Considering the interoperability in cases that might imply an overlap between the DSA and the GDPR, do you believe that there will be entropy between the digital data protection authorities and the national coordinators for the DSA? I think we could start now with Marco. Tiago already talked about the coordinators. Okay.
I think on the last point, I think this is something that it's already happening. If you consider, for example, the interplay between competition law and unfair commercial practice with data protection issues, sometimes it's something that it's already on the docket of the European Court of Justice, and for example, in Italy, it has already been scrutinized a couple of times by the administrative court. So the chance to use the competition law to tackle basically data protection issues, so the abuse of personal data as a way to put in place an unfair commercial practice. And in this case, the decision of the court was that there is no overlapping, because the same point can be tackled on two different points. One is the data protection, the other one is the competition law. So if you use if you abuse the data to put in place an unfair commercial practice, in that case, the competition law will apply, and the authority which is competent for this is the competition authority. In Italy is the antitrust authority. So of course there is clearly an interplay between different kind of sectors, and there will be more and more like this, essentially because we are talking about an economy which is based on data. So it's absolutely normal that if the economy is based on data, both competition law and data protection law will apply. So it depends on the single case. What is important, in my opinion, is that at national level, you have an authority which is independent, so is not subjected to the authority of the government. And this is absolutely an important point, especially, I'm not talking about our countries, the traditional Western European countries, but if you see in the new coming in the European Union from the East, sometimes there is not such a clear difference between the authority which are really independent and the ones that are subjected to the power of the government. So this is a point that could be problematic. Sometimes, you know, today has been released the draft of the adequacy decision of the transfer to the United States of the data. So we have a huge discussion about if that system is adequate enough to receive the European data. But sometimes we have big problem inside Europe. So we have problem in transferring data inside of Europe, but just because this is covered by the GDPR, we don't care about. So it's maybe this is one point to consider. And the other point is that also a lesson learned from the GDPR, the fact that you have one authority, a supervisor authority, a leading authority in the case, maybe sometimes doesn't work so well. So, if it becomes a way for the companies to put the headquarters in a specific country because they know that they can receive a preferential treatment from that authority, maybe this become a little bit tricky. But of course, the role of the other authorities can intervene in this. We experienced many times with Facebook recently, and the role of the European Data Protection Board in correcting some kind of attitudes of the Irish Data Protection Authority. But this is another point that we have to consider.
Yeah, I mean, I haven't talked with Marco before, but I fully agree again. I mean, interplay between regulators, it will always be a problem, okay? Always. I recall a very interesting case, I think it was from 2013, where we had a regulator for a specific sector saying that the operator could do something, and of course the operator started providing a services or offering a product within the boundaries defined by the sectoral regulator. And then the competition authority stepped up and said, no, you can't do that, and applied a major fine to the operator. And of course, the operator would say, but I was doing what the regulator allowed me to do. So why you are fining me? So this interplay is not always easy. It's a challenge, but regulators must talk with each other. Okay, that's something that should not be included. It cannot be included in the law because it's common sense. But regulators should talk with each other and should avoid this kind of difficult interplays or conflicts of jurisdiction. So with the DSA, in my opinion, for sure, we need a national coordinator. I'm not keen to consider that we have different authorities in different sectors supervising the DSA. I don't believe this is the best option. And in fact, we have the case in Portugal, because when we decided to transpose the e-commerce directive, we created different levels of supervision. So we had sectoral supervising authorities, and then we had a residual authority, which was the communications regulator. And this kind of segmentation does not work because everything is now, as mentioned, interoperable, interchange, convergent. So this does not work. I believe that we need a national coordinator. In principle, I would say in Portugal, it's my opinion, I expressed it in other occasions, it should be the communications regulator. I think it is the authority that has the means, as the institutional respect, as the powers in order to supervise this new act, and it's in line with the transposition of the e-commerce directive. And if there is potential conflicts with CNPD, with the competition authority, with other sectoral authorities, regulators must talk. And in some cases, the legislation already provides that between a final decision is reached, for instance, the competition authority, because it is transversal, is multi-sectoral, of course, they need to consider the opinion of the sectoral regulators. That's how things must be done. So if that's the case within the DSA, and there is a decision that needs or requires consulting with CNPD, so let's consult CNPD, let's find their opinion, and then we are going to decide. So that's, in my view, it's the best way to proceed.
Thank you, Tiago. And always with the input of a person which is asked to advise clients and how to navigate these really dark waters and chaotic webs of regulations. I have one final question, but if the members of the public and the audience have questions, please feel free. And if people have been placing questions, if you have an idea right now, would be the opportunity to start writing it. So my question is kind of double-faced. So first of all, as Mark raised on his presentation, the DSA is structured almost in kind of modules of obligations, which rise with the size of the operator, the digital service provider, with different deadlines for the entry of force. And this was the policy decision that took some lessons from the GDPR, which set principles but didn't place benchmarks for how those principles should apply in practice. Do you believe, and this question for both, that this framework is actually useful for small and medium enterprises and achieves what it aims to achieve, in terms of not becoming an excessive burden for these small providers, and also that underlying aim of trying to foster European digital providers, which is kind of an absence in our markets. And the other problem is, even if we have these degrees of different obligations, if there is the risk that the DSA becomes one more market barrier for the entry of new innovative and competitors for the provision of these kind of services. Tiago, if you want to start. I think you're having problems with the camera.
No, sorry, it's it's back to the pandemic. No, I mean, I think the question is very good. I think we are seeing a trend on this matter. So this is not the first act from the European, with some kind of exemptions to micro and small companies. So, of course, the legislator is concerned that the kind of burden at the level of obligations that they are imposing could kill innovative businesses, could undermine very interesting projects that are now undergoing. So we are assisting to this kind of exemption, not only in the DSA, also, for instance, I recall the European Electronic Communications Code, the Consumer Protection Directive. So we have a couple of examples where these exemptions are included. In my view, this is something that is in line with the proportionality principle. So we should tackle and we should impose obligations where they are most needed. Where they are not needed, we should refrain from imposing these obligations. Just a final note, within the DSA, and just is my annotations here, we find exclusions on, for instance, the transparency reporting obligations for micro and small companies. So they are not obliged to publish these transparency reports, which is something important, but because they will save some costs here. They are exempted for all obligations applicable to providers of business to consumer platforms, which I can understand, because we have the know your customer, we have the information, the design requirements. So this implies very huge costs, very background compliance costs. So I can understand that. What I cannot understand, in fact, is small and micro companies are exempted from all obligations regarding online platforms. So we are talking about, for instance, articles 20 to 28, and we have a bunch of obligations here. So the one that Marco mentioned about dark patterns. So micro and small companies are exempted from this requirement. Of course, we have the unfair commerce, the unfair directive on unfair practices that can be applied, the GDPR that can apply, but at least this article is not applicable to these companies. The internal complaints handling system, they are exempted from this, so they don't need to provide, as we were talking, any kind of justification if they make content moderation. So we just find out that our account has been suspended and we don't have any clue on the justification. So they don't have this obligation. For sure they can do it, but they don't have this obligation. They don't have obligations on advertising and profiling. And striking me, they don't have obligations if they provide services to minors, which is the last article 28. And it's a very important protection that we have within the DSA for services that are targeting minors. And so to exclude small and micro companies from these I would say all of the obligation, it seems excessive to me. It seems excessive to me because some of them may not, of course, have the reach that they would like, or that they would compromise some public interest objectives, but they can provide services where the imposition of these kind of obligations are important for consumers, are important for the well-being of everyone. So I don't fully understand this entire exemption from these obligations.
Thank you, Tiago.
Yeah.
Mark, your input,
No,
please.
I totally agree. I totally agree. So let me be provocative. So the aim of these dispositions in the DSA was to provide some kind of preference for the small medium enterprise, the micro small enterprises, so to let them grow without too many obligations. But consider this from the perspective of consumers. Who would you trust? The one who has provision and obligation of protecting minors, the one who has provision and obligation on traceability of commercial operators on the platforms, or the one who has not any of these obligations? So as a user, as consumers, I would prefer to buy on platforms that will guarantee me that there is kind of a traceability on the operators that are on that platforms that apply the know your business customer rule. So, I mean, I understand that the original idea of this kind of exemptions, but maybe the unintended consequences would be that the consumers will be pushed to the traditional platforms, to the bigger ones, because they are more secured. So maybe the unintended consequences would be to push the consumers more and more to the Amazon, to the eBay, and to this kind of operators.
Thank you. It's a very interesting take that the companies themselves have an interest of having this kind of obligations and being able to publicly say, we have to comply with those rules, so you're safe here. It's a very interesting take. Thank you. If we don't have any more questions from the public, I think we have tackled all of the major points of contention and universal minor on this regulation. It was a very interesting evening for us here in Portugal already. So if the public, there's no more questions, I believe our session is arriving at its end. So once again, the professors Graça and Francisco Coutinho are not here with us, but they entrusted me with the function of the sending off, and with Diogo too. So first of all, thank you to our speakers, Tiago, Bessa, and Marco, for this really great conversation, debate on this topic. It was very interesting, and it was a pleasure to have you here sharing your opinions and your experience on these matters. Thank you for all the members on the audience, for all the attention that you paid. And just a few small notices. So next, just as Professor Francisco referred, Professor Graça, it was the one that talked. Next week we'll have our last, this one was the last. The next, it will be a special webinar for the launching of the yearbook on data protection. We hope that you all join us. It is an open access available online, so promoting the dissemination of knowledge always. And we'll launch a new call for papers too at that time for the next yearbook from next year, and the new cycle of webinars for 2023. Marco also has shared with us that there will be a call for papers for Euroconsumers for the participation and presentation in the Web Summit 2023. And that's it. Thank you all for coming. It was a pleasure and a great webinar, I believe.
Thank you very much.
Thank you very much.
Thank you. Have a nice evening. Bye-bye.
Bye-bye.